Thank you very much, Provost Berliner, and I want to thank everyone for coming today. I also want to thank the Distinguished Lecture Committee for selecting me. I want to thank my wife, Ruth Stern, who is here, who is also a co-author of mine. I want to thank Trish Casting, a law librarian for whom I turn to innumerable times, and I want to thank my research assistant, Nicole Della Ragione. But most especially, I want to honor my parents who are here to see me, and it's rare when someone my age has parents who can come and attend. So I'm really thankful for that. Here's the story. Odysseus, who is known as Odysseus the Cunning, or Ulysses for you Latin scholars, is trying to get home to his beloved wife, Penelope. It's taking him 20 years, but as you know, he's so cunning he won't ask for directions. So we pick up the story when Odysseus has to navigate his ship through the narrow passageway between the sea monster Scylla and the giant whirlpool Charybdis. To avoid one is to encounter the other. If you banked away from Charybdis, you fell into the arms of Scylla, and vice versa. Why am I telling you this story? What if the monsters that Odysseus faced represented two different ways to decide child custody cases in America? Let me make Scylla the current legal rule that parenting determinations are case-by-case decisions based upon the standard known as the best interest of the child. This standard is often nominally filtered through a laundry list of factors, 10 or 12 or 14, whatever the state says, the state statute says. But here's the truth. The statutes never prioritize those factors, and only a particularly clumsy judge will ever be reversed. Why is this version of Scylla a monster? Because if the standard for custody decisions is so loose, it encourages damaging litigation since the results are unpredictable. So who is Charybdis in my story? Charybdis is actually a new monster, an ostensibly radical but seemingly sensible proposal making its round around the nation. It took two parents to create the child, so this says, two parents to raise the child, and when the parents separate, there's two of them, there's one child, each child 50%. Let's just do the math. Everybody gets 50% of the kid. 50% of parenting time. That idea has made its way around the country in calls for a legal presumption that joint and physical custody of the child should be the norm, and that joint means 50-50. Why is this Charybdis a monster? Because the presumption on paper bears very little resemblance to the family in the flesh. And the focus on the legal presumption is on the rights of the parents and not the welfare of the child. This monster has not yet been enacted in any state, but I have seen dozens and dozens of bills proposed and making its way through the state houses as we speak. So, what's the modern day Odysseus to do? How did we as a society come to decide custody cases? Why is this process such a mess? And what might be a better alternative? That's the one-sentence summary of my lecture. As with all contemporary issues, history can shed some useful light. I call this historical journey from the rule of one to shared parenting. At common law, in matters of child custody, the English did much as the Romans did. Well into the late 18th century, ancient legal codes assured the fathers of absolute dominion over children and property. Courts dealing with marital dissolution were primarily concerned with the allocation of matrimonial goods, and child custody doctrines evolved as a subset of property rights. Since custody was originally incident to guardianship of lands, the father was seen as the natural guardian of the child. Colonial Americans adopted these traditions to include this quid pro quo between father and child. The father retained the right to the physical custody, labor, and earnings of the child in exchange for the duty to support, educate, and train the child to earn their own livelihoods, or, if a girl, to marry well. In virtually all cases, thus, common law courts awarded sole custodial rights to the father unless the court had determined that the father was a totally unfit parent. Colonial mothers, though deemed worthy of honor and deference, were not endowed with any legally enforceable rights. Now, beginning in the late 18th century and proceeding much more in the 19th century, English courts began adopting a doctrine called parens patriae to sidestep paternal supremacy and to point to the welfare of children. Parens patriae is a legal doctrine that essentially means that the state is the uber parent, and the government can intervene in family life when the children are in jeopardy, as they often are when parents are fighting over custody. Now, although a father's custodial rights continued to be paramount for years, judges became more willing in the course of the 19th century to balance a mother's child-rearing capabilities against a father's superior economic and political standing. These equitable, less formalized familial notions were transplanted into America, and the parens patriae doctrine became the tender years presumption, that children, particularly young children, belonged with their mother when the parents separated. American courts acknowledged the common law rule of father supremacy, but they said times are changing. Big picture in terms of social changes was the Industrial Revolution, which had remade men into marketplace wage earners, and the emergence in cultural terms of a separate sphere for women as domestic caregivers. So mothers were seen as the instinctive custodians for these young children, and in following these dictates, the tender years presumption, tender years doctrine, allocated custody of the mothers upon divorce and separation, a complete 180 from what had gone on in the colonial era. A mother was seen as, in the words of one court, God's own institution for the rearing and upbringing of the child. This 19th century cult of domesticity extolled wifely virtues and elevated mothers to near mythic heights. In the 20th century, progressive-era legislation fortified the role of the state as parens patriae, increasing the power of judges to make determinations about family life and thereby further undercutting the traditional male authority. All right, how do we get to the present day? Well, it took a social revolution to unseat the tender years presumption and to replace it with gender-neutral custody standards. Mounting divorce rates in the 1960s and the ensuing decades fostered a lively debate about custody issues and parenting roles. The movement for gender equality, the rise of fathers' rights groups called attention to the importance of both parents in the care and nurturance of children, as well as a loosening of the link, not ending it, but loosening of the link between gender and parental role. Meanwhile, the demise of the tender years doctrine left courts without a presumption to guide their custody determinations. In lieu of gender-based theories, judges substituted the more inclusive but less definitive best interest standard. Unwittingly, courts succeeded in burdening themselves with case-by-case custody determinations, often involving a battle of experts, lengthy and contested custody litigation. And what's more, the best interest standard seemed to many to engender a risk of excessive judicial discretion, as well as a threat of inconsistency and subjectivity on the part of judges. Now, why do I call this the rule of one to shared parenting? Because the male-dominated colonial presumption and the female-dominated 19th century presumption did not look at the child at all. They were assumptions about the welfare of the child based upon the gender of the parents. The shared parenting is the road we're on, so let's see how we got there. Gender is always in the equation. Courts in the 1970s began to realize that the assumption that a mother keeps the home, performs household duties, and will have time to devote to the children and their welfare simply was not true for many mothers. Such an assumption, one court observed, fails to take into account the realities of the divorced or single mother, who must assume the obligations of both parents and is often not at home caring for the child, but out working. Gender doctrines also dealt with the emerging belief that what a child needs is not a mother, but someone to do mothering. Now, despite the abolition, the nearly universal abolition of the formal tender years presumption. Some judges retain a tendency to prefer that young children remain with their mothers. Even courts articulating the gender-neutral best interest standard often go with the unwritten presumption that children of tender years are best with their mothers. A relic of the common law, it seems that the tender years doctrine is forgotten, but not gone. Now, to varying degrees, states continue to weigh the primary caretaker's role in child rearing as a major factor in making custody determinations, and mothers are still the primary caretakers of the children. A 2011 study found that married mothers spend almost twice as many hours per week in primary child care activities as their fathers. This is less true now than it was in the days of Leave It to Beaver, but it's still true. All right, both the paternal preference rule and the common law, and the tender years presumption that supplanted it later, both signal the law's conviction that custody was indivisible. After a marital breakup, children could properly be raised by only one parent. The other parent might be entitled to limited visitation, but the child belonged to one parent, and the question for the court was deciding which one. Here's an example of a 1913 Arizona statute that I think hits the point very clearly in providing with the courts a very clear guidance as to where the children should go. Except in extreme cases, the legal conventions avoided judicial evaluation of the welfare of the children whose custody was being determined, unless the child would be placed in serious jeopardy by awarding the custody to the legally favored parent, whichever one that was. The paradigmatic rules at play until the late 20th century allowed the courts to determine the result relatively easily by reference to these broad standards and not by consideration of the child's welfare. In either case, whether the father's one or the mother's one, the calculus did not include the best interest of the child except in extraordinary cases. Until the 1970s, courts regularly refused to allow the parents to decide to share custody, even when they wanted to. The Maryland Court of Appeals most famously said in 1934 that the traditional objection to joint custody was that, quote, it divided the control of the child, which is to be avoided as an evil fruitful in the destruction of discipline, in the creation of distrust, and in the production of mental distress in the child. They knew what they were talking about, or they thought so. The dominant view was that a child needed the stability of a single home run by one parent, and that shifting the child from parent to parent would result in a permanent injury to the child by constantly reminding the child that he or she is the center of a parental quarrel. Joint custody arrangements were nearly incomprehensible to most courts. Quote, it is hardly possible for a child to grow up and live a normal, happy life under such circumstances. Now, joint custody is not the same thing as 50-50 custody, as I'll explain later. The change, the social and legal acceptance of some form of joint custody came about in the late 20th and now the beginning years of the 21st century, when parents began assuming more equal child care responsibilities. And within a generation, state legislatures, courts, and scholars saw in joint custody an opportunity for the child to continue a strong and meaningful relationship with both parents, avoiding the treatment of one parent as merely a visitor to the child and alleviating the trauma the child experienced in the marital dissolution. Joint custody also became more popular as a way to avoid the brutal dynamics of adversarial litigation. In many states, and I think this is significant, the vocabulary of child custody law has changed to emphasize shared parenting, decision-making, and parenting plans in place of the more rigid and possessory terms which sound like refugees from the criminal law, terms such as custody and visitation. Now, isn't it amazing how long we as a society have used these inappropriate terms in ordinary discourse and in the law? Custody. What we mean is residential parenting, isn't it? And visitation? What we're actually talking about is parenting time. Legislators, courts, and mental health professionals are in the process of changing these old common law expressions for terms more evocative of mutual parental involvement. Oops. Not moving. All right. Post-separation parenting responsibilities are increasingly addressed as decision-making and parenting time. And parents are often held responsible for drafting parenting plans to structure those decisions as they are reconstituting their families. More than the lexicon is at stake. The aim is to push a culture change. Shared parenting and parenting plans are not only legally more accurate terms, they also assist in nudging public policy in a more helpful and beneficial direction. In Colorado, for example, divorcing parents do not litigate custody and visitation. Instead, they now have a proceeding concerning the allocation of parental responsibilities. And they're encouraged to do so by jointly working out a parenting plan. To paraphrase Alexander Pope, the sound should be an echo to the sense, and here it is. Shared parenting has risks, of course. The primary one is fostering confusion and instability for children at the very time when they need stability and certainty in their lives, particularly if the parents are not committed to the substantial collaboration and communication required for the success of joint custody. Most commentators agree with the New York Court of Appeals that joint custody is encouraged primarily as a voluntary alternative for relatively stable, amicable parents behaving in a mature, civilized fashion, while, on the contrary, as a court-ordered arrangement imposed upon already embattled and embittered parents accusing one another of serious vices and wrongs, it can only enhance familial chaos. A recent national report, co-authored by Marcia Klein Pruitt and myself, stated that the most significant trend in contemporary child custody law is toward greater active involvement by both parents in continuing child rearing, after separation. This area is abuzz with legislative activity. Child custody statutes are frequently amended and bills are regularly introduced calling for more changes. So let's talk about the child custody continuum. In all American states, and in many countries throughout the world, the child's best interest is the paramount consideration in a custody determination. Most states have a fairly comprehensive set of statutory factors, but there's no consensus as to the exact relationship between a determination regarding the best interest of the child and the ultimate decision of joint custody. In other words, there's no clear way to assign weight or value to the individual best interest factors in order to calculate whether an award of joint custody would be assigned. The problem is that the best interest of the child standard does not on its own give you much guidance. Typically, a judge has to consider, as I said, a large number of factors, but there's no priority set among those factors and no clear way to predict the ultimate decision. Sometimes the legal standards give even less guidance. New York, for example, unfortunately. New York's custody statute gives judges a virtual blank check, telling them only to enter orders for custody as in the court's discretion justice requires, having regard to the circumstances of the case and the respective parties and best interests of the child. That says nothing. The statute specifies only certain violence and abuse factors as considerations for custody, but otherwise allows courts to write on a clean slate or, as critics charge, on a slate of their own making. Today, many states have established a rule favoring joint custody. The rule represents the public policy of assuring that children will have frequent and continuing contact with parents who have shown an ability to act in their best interest and to encourage parents to share in the rights and responsibilities of raising their children after divorce or separation. But what does that mean? What is joint custody? What does shared parenting mean? A number of scenarios fit under this umbrella. That both parents have legal custody, that is, decision-making, but only one parent has physical custody, that is, residence. Or that both parents share both decision-making and residence in approximately equal proportions. Or that the parents share decision-making, legal custody, but that one parent predominates in residence for the child. And there are various other permutations. So even decreeing that physical custody will be shared, what if it's to be shared 50-50? What does that mean? That opens the door to lots more questions. Will the child spend alternate days or weeks or fortnights, or what period of time exactly with each parent? Will the child live with one parent on weekends and holidays while residing school days with the other? In light of these permutations, in light of these variations, the joint custody, sole custody distinction should be viewed along a continuum, not a sharp divide. Now, most states distinguish between joint legal and joint physical custody. Marty? Or Mike? I'm sorry, the computer's jammed. I'll keep. Oh, well. These things happen. All right, I'll just have to, if you can try. I'll keep talking. Joint legal custody, that is to say, joint decision-making, means that both parents, oh, there you got it. Thank you. What did you do?
Magic.
Magic, thank you. I am hopelessly incompetent with computers. Joint decision-making means both parents participate equally in making significant long-term decisions regarding their children's health, education, religion, and welfare, the big-ticket items. Joint physical custody, let me see, yay, which is to say shared parenting, means that the child is in the physical care of both parents. But there's no accepted formula as to how that physical care is to be divided. How much does one parent have custody of the child during that time? What do parents need to do to obtain shared parenting rights? Well, the emphasis on mutual consultation and collaboration has led many courts to refuse to sanction joint custody when this communication is lacking. But there's a danger there, because if you say that both parents must consent, then you've given a unilateral veto power to either parent. And that parent can then say, not me, it's not happening. So some states have declared that a court may order joint custody over the objections of a parent. But then one wonders about the quality of the parenting in that home. As one court pointed out, I think rather aptly, the parents not only have to be willing to cooperate in shared parenting, they have to be capable of doing so and of following up. So does shared parenting mean a set and specific division of the child's time? Well, let me give you a definitive legal answer. The answer is yes, sometimes, in some states, depending on the circumstances. But no, not generally, although there is considerable pressure afoot around the country to make 50-50 the legal presumption. Often a joint custody award gives to each of the parents significant but not necessarily equal periods of time during which the child is under the care and supervision of the parents. Here's an example. This is a Tennessee statute. It's a fairly new statute, and I think it says it about right. It quite sensibly provides that the court must decree a custody arrangement in the child's best interest, but that, in my yellow highlight, both parents enjoy the maximum participation possible. That's very, very different than custody standards a generation ago, where moms got custody and dads had Wednesday night at McDonald's and an occasional weekend. This is very, very different. Most states have avoided temporal formulas, but some have mandated specific residential custody percentages. For example, the Nevada Supreme Court held that a statute calling for frequent association and continuing relationship with both parents meant that each parent had to have at least 40% of the year. That's 146 days per year. That's what the Nevada Supreme Court said joint custody meant. Utah law defines physical custody as the child stays with the parent overnight for more than 30% of the year. Minnesota law for some time has a rule saying that it should be 25% of the law, 25% of the time as a minimum. Now that's an interesting law because there have been a lot of politics about that law. A bill was introduced attempting to make Minnesota have a 50-50 presumption. The language of the bill that passed the Minnesota State House actually put it at 45.1%. I don't know why. But they clearly meant to make it almost even. During the legislative process in both houses of the Minnesota State Assembly and State Senate, the number was reduced to 35%, and the governor vetoed it. The governor vetoed it because he said even though this bill had strong support from fathers' rights group and had strong opposition from domestic violence advocates as well as the family law section of the State Bar and the American Academy of Matrimonial Lawyers, the governor said he was swayed by strong opposition to the bill from organizations who work every day with the most challenging divorces and deal with the safety of the parents and children. Prominent Minnesota family law professor Nancy Versteeg said that the governor was right to veto the bill. We do want to promote, she said, healthy ongoing relationships with both parents. That's really important, but for some parents, dividing custody is difficult. It's hard to imagine that 35%, 65% is going to be the right allocation for every family every time. And that individual approach is going to be much better, she said, as opposed to the one-size-fits-all. Bills, legislative bills calling for a 50-50 presumption are regularly introduced in state houses throughout the United States. And they're often accompanied by campaigns by fathers' rights groups claiming that the court system that is currently in place is biased against men. Some of the material examining a 50-50 parenting presumption is quite sensible. This is from a State Bar publication examining the question. But other material insists that there is a gender war and that mothers are winning by playing dirty and by blocking fathers from becoming parents. What's wrong with shared parenting? What's wrong with 50-50 parenting? Nothing is wrong with shared parenting. Nothing is wrong with 50-50 parenting. So why do I sound as if I'm opposed to it? I'm not opposed to shared parenting, of course. But I am opposed to letting a mathematical calculation decide child custody. Let's discuss how a 50-50 presumption would work. First, note that a legal presumption is not the same thing as a general assertion that after divorce, children should spend as much time as possible with each parent. Many states either have or are moving in the direction of that, which is a terrific goal, having the children have frequent contact and association and a continuing relationship with both parents. That's a good development, but that's not what a presumption would do. A presumption of 50-50 would shift the starting point. The starting point for any custody determination would move away from the best interest of the child and start with the best interest of the parents and assume that that was a 50-50 division. How would you divide, how would a judge divide the 168 hours in a week exactly in half so that each parent gets 84 hours of the week? As one commentator phrased, well, I said that, a 50-50 presumption replaces the best interest of the child standard with the best interest of the parent standard. What's a presumption? In general, a presumption is an inference drawn from certain facts that establishes the basic case, which may then be overcome by the introduction of contrary evidence. Okay, so it's likely that what a presumption would do would be to require the parent opposing the 50-50 division to produce sufficient evidence to overcome the presumption and thus shift the burden to the other party. That's the way it works in the law. Now, shifting the burden of proof is something lawyers do every day in regular civil litigation and in criminal litigation. A clear winner and a clear loser are the stakes in civil and criminal litigation. But tell me what shifting the burden of proof means in a case in which the child's welfare is at stake and the parents are litigating over custody. Because the third party in this is the child. The child is usually not represented, not subject to any burden shifting, is indeed the focus of the proceeding. Shifting the burden of proof, I suggest to you, is incomprehensible in that scenario. When the parents are at odds, that's the moment for individualized problem solving, not for a mathematical calculation. Why might a parent oppose 50-50? You may be thinking, this sounds like a good idea. Why would someone oppose it? Well, it could be lots of reasons, ranging from the other parent's difficult work schedule to his or her substance abuse problems or to his or her virtual disappearance from the child's life, or domestic violence. You might be thinking, surely domestic violence would be a valid justification to overcome a 50-50 presumption. Certainly it would be, in theory. But anyone who has seen the video of Ray Rice punching his fiancée unconscious in an elevator must realize that domestic violence is often not taken seriously, even when there's a video, which there never is. Intimate partner abuse tends to be invisible and rarely reported. Despite a clear statutory mandate, courts often fully fail to account for domestic violence. Now, some of the 50-50 presumption bills that have been introduced, that I've reviewed, have made it nearly impossible for a court not to order 50-50 time unless one of the parents has seriously neglected or abused the child. Unless one of the parents is at the verge of having their parental rights terminated, only then may a court not divide the parenting time 50-50. A presumption of 50-50 parenting would minimize greatly the custody factors that a court is normally required to consider in evaluating the best interest of the child. Call this the law of inertia. If a court is told to start the process by assuming 50-50, it'll be difficult for the parent who thinks this is a bad idea to convince the court that the court should have more hearings, spend more time, take more evidence, and risk a possible appeal because you're going against the presumption that's legislatively mandated, when why don't you just take the numbers as they are and divide the child in half? What about social science research? 50-50 parenting presumptions test the limits of those research. Almost 30 years ago, Elizabeth Scott and Andre Dearden identified the two key assumptions in these custody presumptions. The parents will be able to cooperate in raising their child, and that the harm to the child caused by interparental conflict will be outweighed by the benefit of continuing a parent-child relationship with both parents. But these assumptions continue to be problematic 30 years later. Margaret F. Brinig has recently summarized the recent experience of the states with joint custody rules. And she notes that although policies favoring joint custody were popular in the 1980s when several states adopted them, the more recent practice has been to allow joint custody as one of several options rather than to presume that it's in the best interest of children. In other words, Brinig adds, after experimentation with joint custody, some states have realized that continual moving between households may be harmful to children, that the bulk of newly divorced spouses cannot remain as positively involved with each other, a requirement in 50-50 parenting, and that the presumption is causing more litigation in already crowded dockets. What also troubles me greatly is the matter of logistics. How do you divide the child precisely in half? How do you synchronize the parents' work schedules and the children's, we're talking about sometimes several children, school and activity schedules to arrive at that magical 50-50 number? And what counts as parenting time? Certainly the school day does not, but what if one parent accompanies the child on a school field trip? What if both parents attend the same gymnastics competition? Which one gets credit for it? What about piano lessons, ballet, hockey practice, and on and on? Much more significantly, what sense does it make to allow parents who do not live in the same school district to each have 50% of the child's time? How much commuting is the child expected to make so that he or she can travel to each parent? Whose interest is served by that arrangement? What's better? What's better than the 50-50 presumption? What's better than a legal presumption is a parenting plan. A dozen years ago, the American Law Institute, a group of legal scholars, passed or enacted a set of a set of principles for the law of family dissolution. One portion of those principles focused on how to improve the parenting decisions after a breakup of the family. The ALI principle set out a useful definition. Note that the parenting plan should make arrangements for the present and set out dispute resolutions for the inevitable time when the parents are going to have some problems. So both an arrangement for now and an arrangement for then. Now, the ALI principles as a whole have not been adopted throughout the country, but this particular recommendation, this particular phrasing has been quite successful. Many states are now requiring that the question of what to do with the children of divorce, that question change from a demand for custody by one parent to a requirement that both parents work together to create a parenting plan. So what's in a parenting plan? What is it? Parenting plans aim to achieve the public policy that children have frequent and continuing contact with both parents. It's now a quiz. Much though I'd like you to say D, I don't think you're going to. I think the answer is obvious. Of who knows the best interest of the child? So these parenting plans can be crafted from scratch by the parents, or they can be customized from a menu of sample plans available from court, private organizations. They are available all over the internet. I've looked. They should be flexible but fairly detailed, setting out each parent's area of responsibility in dealing with the child's residential and physical care as well as the emotional well-being, both at the time the plan goes into effect and as the child ages and matures. Now, parents may well need assistance in negotiating and drafting these parenting plans. Help is available in the form of mediation and quite a few books and websites which offer guidance to parents trying to work out a plan. Sometimes parents may need a lot of help. Sometimes parents may need 2 or 3 tries or 2 or 3 dozen tries to work out a plan. That's okay. Sensitive lawyers and mediators are standing by. Ideally, these plans should also recognize the likelihood of future parenting disputes by incorporating problem-solving mechanisms such as mediation or collaborative law or parenting coordination, with adjudication in court only as a last resort. If you set these out in the parenting plan, a development that's relatively new, then the parents are directed in which steps to go to prevent them from getting to court too early and from aggravating the situation too early. Unlike a child custody order, a parenting plan can include mechanisms to adjust to the child's developmental changes and to other significant family transformation. Parenting plans are, in a sense, homemade custody resolutions, but they're providing methods for sharing custody more in keeping with child development findings in psychology and less likely to lead to further damaging litigation. And there's plenty of psychological research that shows that litigation is the most harmful thing you can do to a child when the family is at odds. Development of a parenting plan is a significant family law mechanism created in response to the persistent dissatisfaction with the traditional adversarial divorce process, and intended to encourage models emphasizing self-determination and problem-solving approaches. In the last generation, family courts have moved toward a philosophy that supports collaborative, interdisciplinary, interest-based dispute resolution processes and that limits the use of traditional litigation. In short, parenting plans aim at reversing the trend toward a clean break as the social norm in divorce. Husbands and wives may want a clean break from each other, but that is simply not possible in a family with children. The legal system should be engaged, my colleague Andy Shepard often puts it, not in the dissolution of the family, but in the reorganization of the family. Many state statutes are beginning to require parenting plans as part of the process for obtaining shared parenting. New York is, unfortunately, not one of those states. And so part of my focus today is to try to raise this issue among my fellow New Yorkers. The Empire State's divorce law is antiquated in many respects, and one of the worst is the lack of emphasis on non-adversarial methods of making parenting time decisions. Our state statutes need to be amended to reflect the best practices of modern family law, including parenting plans as a necessary component of each divorce case to keep both parents actively involved in their children's lives as possible. Will parenting plans always work? Of course not. Sometimes divorcing parents are so furious at each other that they're unwilling to work constructively to provide for their children's best interest. But this is not news. The failure or refusal of spiteful litigants to work collaboratively to ensure the welfare of their children is a recurrent problem that has plagued the family law system that looks for the best interest of the child as the rubric for decision. And here's the sad part of my story. These folks cannot be stopped. Venomous, vindictive, vengeful parents cannot be dissuaded from trying to destroy each other and the children. The courts deal with these parents. They will continue to deal with these parents. And my proposals have little to say to those extremists. Make no mistake. Parents this crazy will fight over best interests, and they will absolutely fight over presumptions. They don't care about their children. They're using their children as pawns in a gruesome grudge match against their ex-spouse. A presumption will not provide these parents a shortcut to resolve the case. It will only supply them with another angle of attack. But here's the good news. Most divorcing parents are not in that category. Most divorcing parents are trying to do the right thing by their children in a time when they're uncertain or angry or frustrated, but they're trying to do the best for their children. Methods that the legal system can use that help them to continue and deepen their focus on the best interests of the children, I think are to be preferred to methods that force them apart and force them into an adversarial cauldron. These parents, the majority, who are troubled and uncertain about the future, if they come to a legal system that pushes them into traditional litigation, they're likely to respond in kind. And some attorneys, unfortunately, are complicit in this urge to litigate, leading their clients down the road to a courtroom confrontation as if that were the natural way to decide their children's future. The culture of the matrimonial bar in New York has traditionally been hostile to mediation. Many attorneys, we work with them, we work with quite a few of them, and some of them are here in this audience today. We work with them in our family law skills courses at schools, and they are terrific. They're terrific models of good practice and wise counsel. But they're not in the majority yet. What can we do? I think the most promising efforts chart a safer and truer course for Odysseus, remember him, as for us. Now, how can we and our friend Odysseus avoid the scylla of uncertainty emblematic of the somewhat unpredictable best interest test? And how can we all turn away from the Charybdis of the legal presumption that states that child custody is an exercise in algebra? One possible journey through these monsters, here they are together, urges separating and divorcing parents out of the courtroom and into a framework that helps them concentrate on mapping a future for their children. What I'm advocating is a process, not a formula. Here's what the national report prepared by the Association of Family and Conciliation Courts said on these very points. Promotion of shared parenting constitutes a public health issue. When courts make decisions concerning parenting arrangements, they should do so based upon the specific and unique needs of individual children. Children's best interests are furthered by parenting plans providing for continuing and shared parenting relationships that are safe, secure, and developmentally responsive, and which avoid a template calling for a specific division of time imposed upon all parents. Two more. It's inappropriate to have a presumption that covers all situations when not enough is known to verify that the presumption will benefit almost all children and families. And finally, in lieu of a parenting time presumption, a detailed list of the best interest factors should be considered in each case. Moving divorcing parents out of courtrooms and into living rooms to draft parenting plans is a major step in changing the culture of divorce. Will parenting plans always succeed? I say again, of course not. But keep in mind that culture change is usually extraordinarily slow until one day it's the new normal. Our society is already moving in the direction of increasingly shared parenting, and we are collectively, in our typical nudging, budging, fudging way, gradually turning toward parenting plans rather than briefs, mediation rather than litigation, and sharing the parenting rather than dividing the child. The legal and the mental health worlds need to do their best to facilitate this process. I thank you very much for your kind attention. Eric. I'll do just that. Hofstra University is involved in setting up a resource center that I know Herman has been facilitating. This is a center for divorcing and separating parents that will not provide representation to either parent, but rather will provide dispute resolution alternatives so that parents who have a child custody issue, parents who are at the point of divorce or separation, they don't need to be married, but they have children, they can come to the center and we will have, with the cooperation of the psychology department and the law school, a menu of choices for them that involve dispute resolution methods, mediation, therapy if that's what they need, whatever they need, and drafting an agreement should they be able to successfully conclude that would allow them to bypass the litigation process. Thank you. Yes. Anybody else? Wow. Thank you very much. Yeah, thank you.
It's amazing. Thank you very much.
Was that?
Very
Whoops,
common,
let me
very
kill
common,
this so I don't.
Very common sense talk, so I think that's